session.
Thank you. You may be seated. We're here today on our case number 1CA SA180114, Lay versus Honorable Roger A. Nelson, respondent judge. Counsel, as you know, each side has 20 minutes for your argument. The petitioner may use any amount you'd like to reserve in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount of time you have remaining, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to both of you if you would, when you approach the podium, give us your name and the name of your client for the recording. We have read all of the filings and the record and all of the briefs, and we're grateful to the parties and to the amici for their briefs. I don't know if the amici are here, but grateful to that for that assistance as well. So we've also spent some time in our conference this morning talking about the matter. So with that, you may proceed.
May it please the court. My name is Greg Torak. I represent Jason Lay, counsel. First of all, it's a privilege to be here, and I certainly appreciate the efforts that the court has gone to learn about Mr. Lay's case, and also I do appreciate the briefs of the amicus parties. They certainly elevated the discussion, I think, which is greatly appreciated. The first thing that my client would like to impress upon the court is what the meaning of, or what the direction that the jurisdictional statute ARS 22301 is, and specifically with reference to the meaning of the results of such conduct. And that's really, I think, what the court is focused on, probably should be focused on. What we know from the similar case law or the similar statute in the Superior Court cases and the case law is that certainly it would mean the results of such conduct would mean if there is a direct and immediate effect on the victim in this particular case. It would also mean if the design of the crime was such that it was geared to affect the victim in the particular jurisdiction. In other words, does it have geographical components to the crime? And finally, if the nature of the offense, and this is not in the case law, but this is something that the brief from the AACJ suggested, is that if the nature of the offense is such that there is perhaps a continuing harm, that might also trigger a situation where there was a victim who was impacted in one location and then went to the home jurisdiction where the prosecution took place thereafter.
Well, counsel, don't we have that in this case, in the result or one of the nature of these is harassment or fear, the threat? And that doesn't just stop at the time the words are spoken or the texts are sent.
I think first off, the two charges are a little bit different in nature, and I think that the harassment charge is a little more is a little easier to dispose of than the threats charge. But and I'll come back and make that distinguish those in just a second. But notwithstanding that fact, in this case in particular, there wasn't any evidence that there was this continuing harm when the victim and her boyfriend returned to her house. In other words, there wasn't evidence where she said, "I feel harassed," for example. There wasn't evidence.
She never said that when she spoke to the police officer back at her home?
I don't recall any evidence that where she would say that, where she said that, being produced at trial.
Well, if she hadn't told the officer she felt harassed, do we even have a crime?
Well, We would have a crime where the call occurred if a reasonable person would feel harassed from the nature of the phone call.
So in how many minutes it took from when she took the phone call till when she got to her new boyfriend's residence, if she suddenly no longer felt harassed?
Well, that brings up a very good question, and that is how long do we have this cloud of harassment that follows a person? Is it going to follow for 5 minutes, 10 minutes, an hour, a day, a month, 6 months?
Well, it's a much harder question depending on the length of time, correct?
I think that should be a factor involved in certain situations. In the threat situation, I think it would. But the distinguishing
But you feel threatened one moment? Because I could see it in a face-to-face threat where the victim has now left, and so the person is no longer there. But this is not a face-to-face threat. And I'm just paraphrasing. I'm going to get you. I'm going to kill you. I'm going to do whatever the threat was. Since it's not face-to-face, that implies it's some future time, correct?
Yes.
So he would feel threatened until he no longer feels threatened. I mean, I'm not trying to make light of it, but when does that feeling of being threatened dissipate?
Again, I think that's a more difficult call than the harassment situation because of the nature of the crime. And I think this is the point that that Mr. Stenfield was getting at with the AACJ brief, is that certain crimes may intrinsically have a continuing harm to them. And I think threatening and intimidating would be one of those crimes. But the harassment crime is different in that the act of the harassment was the phone call and the feeling that the victim had at that time. And when the phone call was over with, the act of harassment was complete. It was done. It's not something that follows the victim around in perpetuity or until she says she doesn't feel harassed any longer.
Well, although I just checked because I get the two statutes confused, and harassment actually requires that the victim be seriously alarmed, annoyed, or harassed. So it seems to me the natural result of that crime would continue as long as she feels that way, wherever she is. But let me ask you, if you have any response to the argument made by the Attorney General that the statute, the Section C, I believe, of the statute, 223001 C, is not a matter of subject matter jurisdiction. The argument that the AG makes is that we know that because there are change of venue statutes that follow in line. And if 22301 was meant to establish the location at which the Justice Court has subject matter jurisdiction, then the precinct statutes would be superfluous.
It was a very well thought out brief. It was a very voluminous brief. I enjoyed reading it.
It was long.
I think in order to buy into the argument from the Attorney General's office, we have to disbelieve that the jurisdictional statutes that have been set forth for the Justice Court are not jurisdictional statutes. They're venue statutes. And that's just really a bridge too far for my client to make. If the jurisdiction is not proper, the appropriate remedy is to dismiss and refile in a different justice court. That's the appropriate remedy. Whereas in Superior Court, that it may be a different analysis, and I think the analysis is more pegged to the Superior Court perspective.
Okay. So in this case, what do you think is the extent of what do you think is the geographical extent of the results of the two respective crimes?
All right. So, are you asking me is the jurisdictional I'm not sure I quite understand
I'm
your
sorry,
question.
it was a bad question. Take the threat crime. Is it your position that the result of that occurred only at the location at which the phone call was received?
In this particular case?
Made?
In this particular case, yes. But that doesn't mean that it is always that way. What we have to look at, again, is looking at some of these tests that we have. Where was the direct, immediate effect? Well, that was at the location that was not in what we can maybe call the home jurisdiction. Did the crime have any geographical components to it? Well, that's why I think threats is a little different than harassment. It might. I mean, it might have a component where the person should feel that you're trying to make feel threatened would carry that with them, and that might be a fair assessment. And was the nature of the offense threatening, intimidating? Does it have as its one of its core intrinsic characteristics a continuing harm that would travel from jurisdiction to jurisdiction? And yes, threatening, intimidating might be that. For example, an assault. We have different flavors of assault at the misdemeanor level. We have an assault where there's placing somebody in immediate apprehension of physical harm, and then we have an assault where somebody's injured. And the injury component would be one where it might travel from location to location, but placing somebody in immediate apprehension of physical harm would only happen at a time and a place where it actually occurred. And so my client's perspective is that the harassment is of more like the economic type of harm that Miller talked about, and it's more like the assault type of harm where someone is placed in immediate apprehension of physical harm, whereas the threats could be distinguished in that regard.
So could be distinguished. So are you saying might provide jurisdiction here?
In some situations, yes. In this particular case,
in this
no.
Case.
No.
So let's say you have a threat, and you have a victim driving along, sees a text, and there's a threatening communication, and she's on her way home. She receives it in one precinct. Her home is in another precinct. She gets home. She can't sleep. She's throwing up because of anxiety. Are those results sufficient enough to convey jurisdiction?
Again, I think there's a factual component to it and there's a legal component to it. And yes, I think with that particular crime, the legal component is there. It could be fulfilled. And with the fact pattern that you set forth, yes, I think that there would be a jurisdictional case to be made there.
So let's look at this case. Among the threats were one of revenge porn. Is that correct? That I have 100 pictures of you naked, and I'm going to disseminate them. Is that accurate?
No, sir. It is accurate with regard to the harassment crime. That was part of the harassment of the female victim.
Right.
The male victim was the one who had the threats.
Let's focus on the female victim
Yes,
right
sir.
now. So we have that threat conveyed via text or phone call. Is it your position that the only appropriate jurisdiction in which that claim can be brought is where the victim first learns of the threat of harassment, the harassment?
With a harassment
The catchy
charge, yes. Yes, and the distinction again is in the intrinsic nature of the crime. Yes, because the harassment is the communication. It is the communication that started and stopped in some other location than the home jurisdiction.
I thought with harassment you were looking at a body of work. You were looking at many types of, it's coming and there's a text today and a phone call or a lot of phone calls. And is one text harassment?
Well, in general, I think it could be, sure. One text could be harassment. I guess it depends on what the content of the text or the phone call is.
If you're looking at a body of work, though, I mean, wasn't she harassed not only that I got those phone calls today, but I'm going to get more phone calls because there's a pattern of behavior here?
Well, as far as the relationship between these two people, the relationship went back quite a long way, and there was good times and there were bad times. I think what the Justice Court was focused on was the communication that occurred on the particular day that was contained in the complaint. I would respectfully say that he was not convicted of multiple acts that occurred over multiple dates and in multiple different locations.
So let's go back to your harassment as a singular moment in time. Doesn't the statute use the word results, meaning the consequence of conduct? Isn't that relevant to the analysis expressly under the statute?
Yes, and I mean that's why we're here. What does that mean? What does that results mean? And from my client's perspective, it means several different things. There's several different tests that can be applied, but one test would not be where it is a subjective analysis of a victim's feelings. And the reason we know that is because the subjective analysis of the economic deprivation does not give rise to jurisdiction under the same sort of statute in Superior Court.
What about an objective test? You threaten a woman with posting 100 naked pictures. The reasonable woman might have concern extending 10, 15 minutes into the future.
Well, I certainly appreciate the example. The problem with the example is that it sort of goes beyond just the harassment. A post is forever, but this is a phone call. And
right, but we look at the result of that phone call, correct?
Yes. If we were to take your example and say the post was made and then somehow deleted and erased from whatever server forever.
Yeah, I'm not saying anything about posting.
Oh, I'm sorry.
I'm just saying I'm going to post.
Okay.
All right, you have a phone call, a text. I got these 100 pictures. They're going on the internet. Boom, that's it. Seems to me that the result might extend beyond that singular moment in time.
Well, the state could have charged him with some different crimes, and they didn't prove him guilty of other crimes. So he could have been charged very easily with disorderly conduct, which is basically disturbing the peace of another individual, and that might continue on. But he was charged with harassment of the communication flavor. And that's really the distinction here. The communication started and stopped in some other jurisdiction.
But it might have started and stopped in some other jurisdiction, but doesn't the statute expressly direct us to look at the results of that conduct, which didn't necessarily stop in some other jurisdiction?
The statute does. 22-301 says that we have to look at the results of the conduct. And so that's really the question. Where are we? What does that mean exactly? And if the court is going to say that it means that the cloud of harassment can follow a victim wherever they go throughout the state of Arizona, and that the defendant can be prosecuted in any jurisdiction, I suppose that's one perspective. That's certainly not the perspective my client has. With reference to the limiting jurisdictional language, it would be only in the location where an element of the crime occurred or the result. And the result means one of these three different categories of things. A direct, immediate effect, or if the design of the crime was such to have a result in that particular location, which is not the situation here, or that the nature of the offense intrinsically had some characteristic to it where it would potentially carry forward, such as the assault where there's this continuing injury.
Before you sit down, what are the cases you are referring to? Just give us the names to make sure we got them all covered.
Yes. Yegan,
Okay.
Flores, and Miller.
Miller, okay. Very good. Thank you.
Thank you very much.
Morning. May it please the court, Andrew Roscoe on behalf of the state, from the Deputy County Attorney from John Smith's Office of the Yuma County Attorney's Office. Your Honors, this statute at the heart of this case deals with matters of territorial jurisdiction and venue, not subject matter jurisdiction.
Why does it say jurisdiction then?
Yes, when looking at a statute, lots of times the starting point is look at the plain text, how do we and make an interpretation off of there. Unfortunately, jurisdiction arguably has a lot of ambiguous elements to it. Just by its very nature, the name alone comprises of multitudes of different varieties of things. Could be personal jurisdiction, could be specific or general jurisdiction of personal jurisdiction, could be territorial jurisdiction, could be subject matter jurisdiction, could be dealing with venue. There are a swath of a variety of things that jurisdiction can go into. And there are other things too, when looking at the statute, that lead to a different interpretation, that it's not subject matter jurisdiction, but rather goes into matters of territorial jurisdiction and venue. One of the key things is that the statutes right after it, 22-302 to 304, those are matters involving venue. Now, subject matter jurisdiction, it goes to the power of the court. Parties can volunteer to take a case elsewhere all they want, but if they do not have subject matter jurisdiction, the very power to adjudicate the case, then it can't be done.
So, true, absolutely true. So I suppose you might construe the subsequent venue statutes to mean that venue may be transferred to another precinct that has subject matter jurisdiction.
Yes.
In fact, it can only be transferred.
Yes, Your Honor. And because like when we deal with subject matter jurisdiction, it goes to like, are these the class of cases that the legislature has authorized this court to hear such a case? It's very similar to like how one would approach federal questions, say, is there a law here arising under, say, the Constitution, the law of the federal government? Here, as prescribed in 22-301, harassment and threatening are misdemeanor offenses arising under the state of Arizona. That meets the subject matter jurisdiction here. Because a lot of implications that can come into this is that also precincts can be fluid. They can be destroyed. They can be moved around. In our county, recently in my experiences, you had like the first precinct and the third precinct, and there's a checkpoint where the precincts would move suddenly and encompass one area versus another. And if subject matter jurisdiction really is something that cannot be waived, then it calls into serious question then prior adjudications on that matter, because it's no longer in the proper precinct.
Well, but it was at the time it was prosecuted. What do you make? Where does the term territorial jurisdiction come from, and what does it mean? I mean, I read in the state's brief about that concept, or the AG's brief about that concept, and that brief cites the Willoughby case. But I don't understand that Willoughby to be talking about something other than subject matter jurisdiction until it gets to the Sixth Amendment vicinage discussion.
Mm-hmm. And it's merely a very subtle thing. And even in like the restatement on judgments, they have a comment section emphasizing the importance of separating territorial versus subject matter jurisdiction.
What's that? Do you know what that is? Can you read that?
You said there was restatement.
The restatement, the second restatement, involving judgments.
Of judgment?
Yeah, there's a section involving territorial jurisdiction and subject matter jurisdiction. Obviously, those sources have their own limitations because much of it is going into a matter of like civil, as it refers to many times, on like territorial jurisdiction as transactions, so to speak. Territorial jurisdiction, in a lot of ways, is synonymous with personal jurisdiction. A lot of the analysis goes into the same ways, where it's like minimum contacts, the claim arising from the action. In the context for criminal matters, it would seem to be that it's only a specific territorial jurisdiction, or as specific personal jurisdiction. There's none of this kind of like, or the minimum contacts for the state or domicile or anything like that that distinguishes from its personal jurisdiction counterpart. Now,
Well, what cases other than Willoughby talk about something by the name of territorial jurisdiction in a context other than subject matter jurisdiction?
yes, Your Honor. And for cases like that, while it doesn't go into a heavy amount of detail, State v. Womack approaches.
It doesn't go into any detail.
It doesn't. But the key emphasis here is that the defendant was making this claim. Its central claim was under subject matter jurisdiction, and the court rejected it as under a belief that they had waived these preliminary motions of the like, something that does not apply to subject matter jurisdiction. Another one.
Counsel, the cases that you've cited and that the AG cited when it talks about this, aren't we talking about competing sovereigns? I mean, Willoughby, it was who should have this crime, Mexico or Arizona? In these other cases, we're talking about where the crime should be tried, Arizona, Utah, Nevada, Colorado. Mm-hmm. We don't have competing sovereigns here. We're talking about whether or not this particular precinct has subject matter jurisdiction over this particular crime. And the legislature set it out. I mean, they couldn't be any clearer. They say jurisdiction of criminal actions. Mm-hmm. Isn't that what they said? In 22-301?
Yes, it references jurisdiction, Your Honor. The state goes back to its original points. Like, when we are dealing with a term that is susceptible to ambiguity, it falls then on looking at the rest of the statutory scheme.
Well, can we focus on 301 and talk about the results? Is it your position that the results of this crime happened in Precinct 1?
Yes, Your Honor. In this situation, you have a defendant who, ceaseless, nonstop, despite multiple times being told to leave her alone, this defendant constantly and without any reservation repeatedly reaches out to contact this individual and makes threats to her and makes threats to Mr. Wagner in terms of going to kill him. And those things don't evaporate. When someone gets that kind of...
And you answered my question. Now I want to ask you another question. That is, if the results don't end when the communication occurs, and that we can look factually, what's the limitation?
We are no strangers to looking at someone's mental state and making a judgment call as how much merit to give it. A prime example is with like excited utterances. How far do we go in time to say, okay, this is of a reliable nature that we can bring it into court, and past this point, not so. And here we have a situation where these people are receiving serious harassment, serious threats. As the harassment defines it, the person is seriously disturbed or alarmed. They call 911 and they immediately go
And say she's an NAU student and she has to get to class the next day, so she drives to Flagstaff the next day. Does the Flagstaff precinct have jurisdiction over that crime because she continues to feel alarmed?
And Prescott, because she drove through it?
And Phoenix, because she stopped over to talk to her mother before she drove up to Flagstaff.
And the state would propose that it would probably depend on like the severity of these offenses, nature of it, and
We're
distance.
talking about the same offense.
Okay,
Everything
same
that
offense.
happened
Same phone
here.
call. Same phone call.
Only her resident isn't in precinct 1. It's in
Flagstaff.
she lives in Flagstaff.
Okay. In Flagstaff, it might be more questionable whether there is necessarily jurisdiction. That is a significantly giant leap from.
Why is that? You just told me that we have the ability to look at the mental state. Well, we're asking what's the limitation? Do you have a limitation you'd like to offer us about? Well, it only until it dissipates when X happens, or time frame. I mean, or is it a month? Is it a week? What limitation do you want to offer to the court to say this is when it would stop?
The state would propose, Your Honor, at least for some measures of limitation in terms of would a reasonable person still be experiencing the chief effects of the harassment or the threats, especially for offenses of this nature, that the chief evil is the mental state that it inflicts on its victims. Nobody cares about the words in themselves that are said. It's the effects that they have on those individuals.
So that's a test of how long the effects last. They depend on what is said and probably the history of the parties. Am I going to believe this or not, and so forth. But say the test concludes, makes you think, okay, it's going to last an hour, or it's going to last 24 hours. Wouldn't it be natural then under the statute to say, well, the venue, the subject matter jurisdiction extends for wherever the victim goes within that hour or 24-hour period?
And there doesn't seem to be necessarily a compelling reason that would stop just because someone, say, in a short time span of an hour goes to various different locations. The law says like any part of where elements of a crime occurs can claim jurisdiction.
So under the hypothetical then, the justice courts in Prescott, Phoenix, and Flag all would be able to try this case.
And we're looking at elements. We're talking about results, but go ahead.
Yes, that too.
Is that right?
Yeah. Yes, Your Honor. The statute lays out like elements of the offense as well as the results. It doesn't paint a particular distinction between the two in the text. And again, would a reasonable person having driven up from NAU to Tucson, I think if I heard you correctly.
Oh, no, she wouldn't go south. She'd go Phoenix, Prescott, Flagstaff.
Okay. In that kind of time span, then, yes, with these kinds of situations, especially in this case where you have a person who's getting a threat to release photos to friends and family, person's now wondering, have they been released yet? Are my friends about to find out? Is this online?
She's going to feel that for a 24-hour period, and wherever she goes within 24 hours, that's fair game.
Yeah, there's a very good case. Like, that is a very seriously and disturbing. Very few people undergo that kind of experience. Or say Mr. Wagner, when he's seeing this voice saying he's dead, he's going to be killed, he's now probably going to be like, do I have to leave my home? Do I have to live somewhere else? Very serious charges and things that this defendant is claiming to do against these victims. Such things don't just go away. And reasonable victims, at least in like a 24-hour period, could easily be feeling those kinds of consequences. That's very real concern.
Let's get to what evidence needs to be offered at trial to satisfy the requirement. Would you agree that the state has the burden to show that whatever subject matter jurisdiction requirements have been satisfied at trial?
Yes, the subject matter jurisdiction elements have been met. They go to the very elements of the charge. That is what a fact finder is meant for. In terms of jurisdiction, again, with like Rule 16.1, Rule 10.3D, they lay out these rules that the substantive motions dealing with jurisdiction during with venue, they are waived if they are not something contested or put in issue by the defense.
What authority for the proposition that subject matter jurisdiction may be waived if the defense doesn't make the motion before trial?
So, Your Honor, Willoughby makes references to its case law, and it was dealing with the constitutional aspects of it, where it was laying out that venue could be waived if it was not contested or prior. And
But if we decided subject matter jurisdiction, it's not waivable, right?
if the court decides that that it is subject matter jurisdiction, then yes, it is not waivable in that context.
Can we talk just a little bit in that vein? The evidence in this case, there was a phone call or phone calls that were made, and is there any dispute that the defendant was in precinct 1 when he made the phone call?
I don't believe that was established
We don't know
at
where
trial.
he made the phone calls.
It was not established where exactly he was when he made those phone calls to the victims.
The two victims were in precinct 1 when they received the phone calls.
That was not established at trial on the record when they received it.
I thought there was testimony they were at the tattoo parlor.
They were at the
The
tattoo shop.
location, was the location of the tattoo parlor established?
Oh, yes.
Okay.
Okay, so
okay.
they were at the tattoo parlor, and that's in precinct 1. And my question is, how much time from the tattoo parlor to the residence did they go? I mean, how much time it elapsed? They call the 911 operator. The 911 operator says, "Go home." They go home. And how much time has elapsed?
Now, for that occasion on the record at the trial, it wasn't established how much time was in between.
Minutes, hours, days?
The trial court was within its discretion in looking at the evidence that was supplied to inference that not a whole lot of time happened between that tattoo shop
Can
and
you
when
give me a ballpark? A month. Less than a month.
probably less than a month between the time they left the tattoo shop to when they got there. There was no articulation from the officer that a significant time had expanded between the moment they were instructed to go to the home and when he met them.
What's the evidence? I mean, you're saying the trial court is in its discretion, I think is the word you used. Based on what evidence?
So the evidence is that, well, for starters, it's the same day.
Okay, we know it's the same day.
It is the same day.
So when I said less, you could have said, yeah, it was the same day.
And my
Not
apologies.
hours or minutes, but the same day.
The same day at the very least, Your Honor. The officers put no emphasis on like a significant time span either between the moment that he met the officer or even when he met Mr. Lay himself. And
That all happened the same day.
that all happened the same day. And it's kind of synonymous with like circumstantial evidence with State v. Howe. And granted, the evidence in that case is a little bit more stronger, but in that case also, like there was, when the kid, it was basically a defendant receiving stolen property. And when these minors had given it to him, they were saying, this is stolen, this is hot, even though there wasn't a precise time frame between when they stole it from a location in Phoenix to where the defendant's business was. Again, This goes to the intended consequences. Yegan, Flores, they all go to this. This defendant targeted these individuals, these residents living within the jurisdiction.
Are there any cases that have not been mentioned today that we should be aware of? Yegan, Flores, Miller. You just mentioned State versus Howe. Is that in your brief?
It was not. It was something I.
What's the site?
The site is 69 Arizona 199.
Okay.
And
Are there any other cases we should be aware of?
to my knowledge, Your Honor, no.
Okay, thank you.
All right. Thank you.
Thank you. If I could just please address one factual issue, and maybe I misheard, but counsel was asked whether or not the phone calls were received by the victims in Precinct 1, and that is not what happened. Or let me say it this way.
Wherever the tattoo parlor was, that's where they received the phone calls.
Right, and the tattoo parlor was not established at trial to be in Precinct 1.
Well, I'm sorry.
No, good.
We can take judicial notice of where the tattoo parlor is.
No, sir, you cannot, and that's why
not?
we're here, because there's no address given. And where we live is right on the corner of California and Mexico. And there's and I'm not avowing to the court what the facts are, that's for sure, but Winter Haven, California is within a mile of my office in the Superior Court and in Justice Court Precinct 1. Mexico is within 15 minutes. So there was no evidence to demonstrate that the phone calls were received in Justice Court Precinct 1. That's really what gives rise to this argument.
But if the tattoo parlor is in Yuma, it's either in Precinct 1 or Precinct 2.
There's, well, it was not established to be in Yuma. That nobody ever proved at trial where the tattoo parlor was.
Okay.
It is, I'm sorry.
But we do know, do we, that the female victim's home is located in Precinct 1?
Yes, that was established through an officer. The officer testified the victim lives in Precinct 1.
Okay.
Thank you.
Well, thank you. Thank you both sets of lawyers for your argument. We're grateful for your briefing. We'll take the matter under advisement and we'll issue a decision in due course. Now we'll adjourn.